So today, yay, we start the final leg of the journey. This is my recurring dream. Everybody's got a recurring dream or two. Aside from the one that I'm sure many of you also have, which is you realize at 5 minutes to 2 that you've got a university exam in a university subject and you didn't take any of the classes or read any of the material, which is recurring dream number 1. Recurring dream number 2 for me, my whole life has been about climbing a mountain, which I never get to the peak of. So here we are. We will not get to the peak of this one, just like my dream. But hopefully we will get as close as possible. So we've gone through creating, connecting, and controlling, as you know. Now we're going to try as much as we can to bring it together. And I needed a C, so conciliation was the best that I could think of, but am very open to other suggestions. Before we get there, any questions on anything we've done so far? Certainly have been corresponding, talking, meeting with lots of you about the papers, and that's been just great because it's wonderful to see how good you want the papers to be. All right. So now, as advertised, ooh, what did I just do here? I didn't mean to do that. Oh, there we go. As advertised, what do these two cases that we dealt with in completely separate parts of the course that apparently, at least on their face, have nothing to do with each other, what do they have to do with each other? So, you know, I insist on calling it the Schwarzenegger case. It is actually the Brown case. It was Schwarzenegger in the Court of Appeal because that's when Arnold Schwarzenegger was Governor Schwarzenegger. Then Jerry Brown took over, and by the time it got to the US Supreme Court, it was Brown versus EMA. Many of us just insist on calling it Schwarzenegger because it's always fun to refer to the star of violent movies trying to eliminate violence from video games. It's too delicious an irony to just walk past, and I am as weak as the next person. Then we've got Davidson, which is really the Blizzard case. All these cases are sort of misnamed, but Davidson being the corporate name. And that's the BnetD case, which you will recall is BattleNet versus the modders who reverse engineered and recast BattleNet as a better piece of software, a little bit more in the modder's image, while Blizzard had their own online service, which included commercials, and the modders obviously didn't. And by that hangs the tale. After much frou-frou, both courts, including the Court of Appeal, rejected the mods. So I ask again, what do these cases have to do with each other? Because they're pretty far apart. So now back to Schwarzenegger. Schwarzenegger is going to be the tougher case in In the BnetD case in Davidson, what's really going on becomes very clear and is very clearly telegraphed. And I'll more than parse it out for you. I'll almost show it to you. Schwarzenegger is more difficult, and nowhere does the court, I think, get to the absolute core point. But we'll talk about that. But just to quickly take you back in Schwarzenegger, here's the actual statute. Thought I'd cull it out and put it up for you. Violent video game means a video game where the range of options includes killing, maiming, dismembering, or sexually assaulting. And a reasonable person would have to consider that the games appeal to a deviant or morbid interest of minors. And that there's patent offense to prevailing community standards, and that there's no artistic, literary, or political merit. So it needs all of those things to transcend the California Act. And just because I'm in an ironic mood, I threw a paragraph out of the Khalil Gibran paragraph about poem about children that you will all know. So what does Schwarzenegger / Brown find? A lot of things we've talked about in the course. So I'll call them out right now. Correlation, not causation. Nearly all the research is based on correlation, not evidence of causation, and most of the studies suffer from significant admitted flaws in methodology. Then I'm just going to focus you, I didn't mean to do that. Focus you on the bottom of the first paragraph, which talks about historical antecedents. Snow White, the wicked queen, is made to dance in red-hot slippers, quote, till she fell dead on the floor, a sad example of envy and jealousy. Cinderella's evil stepsisters have their eyes pecked out by doves, and Hansel and Gretel kill their captor by baking her in an oven. Then bottom paragraph. Also, all these things have antecedents in stuff we've talked about. In the 1800s, dime novels depicting crime and penny dreadfuls were blamed in some quarters for juvenile delinquency. When motion pictures came along, they became the villains instead. Radio dramas were next, and then came comic books. And of course, after comic books came television and music lyrics. And then just a touch of controversy for you to decide for yourself. What's the impact of interactivity? Core meme of this course. Does it affect the violence issue in terms of children? Does it affect what a court should decide after many, many years of finding in the United States that violence should not be, or the depiction of violence, should not be a cause of state intervention in terms of its reception by children, although sexual material, most certainly in the American idiom, should be and can be and is sanctioned by the US courts and the US system. So we have Scalia, Justice Scalia, at the top saying that interactivity is nothing new. and nothing different. And there have been antecedents to interactivity, and we shouldn't get overly fussed by it. And then at the bottom, Justice Alito finding the medium of video games so compelling that maybe, even though his opinion was a concurring opinion, maybe there's something different here. And maybe in the future, the courts need to look at that more carefully. Don't know what you guys think, and I'm very interested. But from my perspective, the point really emerges from the changing mediums point. First, it was the town crier who I'm sure seemed like he was corrupting the morals of youth. And then books, and then newspapers, and then comic books, and then movies. And every medium becomes or seems to become more powerful, seems to have overwhelming power when it first emerges. And now, of course, as we've seen in the course, we are now moving to that next level of complete immersion in the real world. And if you're following the news from GDC this week, 3D headsets that really look like they're going to work extremely well. So I'm going to suggest to you that in our search for common denominators, just go to some audio. And the dead giveaway and the easy one is Blizzard and BM ETD. And I'm going to play it first. And this is in the 8th Circuit Court of Appeal in Davidson. And this is counsel for the respondent, Blizzard, the party that succeeded, against the modders. And in a very, very short clip, less than a minute, you will see, and I will talk a lot more about modding shortly, but I believe you will see the key.
Spend this kind of resources to invent new games, knowing that they'd be pirated, but in some way we would still be able to recover by people wanting authentic games so they could play online, advertising, and so forth.
Okay, here it goes.
This case does not involve new creation. There may be a case that does. This isn't it. This case, as Judge Shaw found, involves tinkering and piracy. The DMCA and our contract work to keep creation at its height. And that's what's at the heart of the copyright laws, continued creation.
Modding is characterized here as not being creation. Did you hear the fear? The fear was that modding might be considered a creative act. And I suggest that learned counsel knew that if it was, there's a whole other path that has to be gone down, a whole other legal path. But if you accept, and if you can get the court to accept, that this was purely a technical exercise. This wasn't art. This wasn't creation. This was reverse engineering a pure technical facility that freedom of expression arguments and all the arguments attendant to creativity don't have to be dealt with, as in fact they were not in this case. So now pretty well telegraphed the answer, because you know the keyword, want to play, and these are more fun, want to play argument. There's so much you can learn from argument. I mean, take this away as future counsel. There's an awful lot of argument that's available to you on the web. Listen to it. Listen to it in the cases you're interested in, because you'll learn so much. And the additional dimension, this course is all about additional dimensions of interactivity. Well, just the additional dimension of audio when you're listening to great counsel arguing, you will learn so much from. So this is the very beginning of the Schwarzenegger case in the US Supreme Court.
We'll hear argument first this morning in case 08-1448, Schwarzenegger versus Entertainment Merchants Association. Mr. Morazzini.
Mr. Chief Justice, and may it please the court. The California law at issue today before this court differs from the New York law at issue in Ginsburg in only one respect. Where New York was concerned with minors' access to harmful sexual material outside the guidance of a parent, California is no less concerned with a minor's access to the deviant level of violence that is presented in a certain category of video games that can be no less harmful to the development of minors. When this court in Ginsburg crafted a rule of law that permits states to regulate a minor's access to such material outside the presence of a parent, it did so for two fundamental reasons that are equally applicable this morning in this case. First, this rule permits parents' claim to authority in their own household to direct the upbringing and the development of their children. And secondly, this rule promotes the state's independent interest in helping parents protect the well-being of children in those instances when parents cannot be present. So this morning, California asked this court to adopt a rule of law that permits states to restrict minors' ability to purchase deviant, violent video games that the legislature has determined can be harmful to the development.
What's a deviant violent video game as opposed to a normal violent video game?
Yes, Your Honor. Deviant would be departing from established norms.
Now, there are established norms of violence.
Well, I think if we look back...
I mean, some of the Grimm's fairy tales are quite grim, to tell you the truth.
Agreed, Your Honor. But the level of violence...
Are they okay? You going to ban them too?
Not at all, Your Honor.
What's the difference? I mean, if you are
Ginsburg.
supposing a category of violent materials dangerous to children, then how do you cut it off with video games? What about films? What about comic books? Grimm's fairy tales? Why are video games special? Or does your principle extend to all deviant, violent materials in whatever form?
No, Your Honor. That's why I believe California incorporated the three prongs of the Miller Standard. So it's not just deviant violence. It's not just patently offensive violence. It's violence that meets all three of the terms set forth.
I think that misses Justice Ginsburg's question, which was, why just video games? Why not movies, for example, as well?
Sure, Your Honor. The California legislature was presented with substantial evidence that demonstrates that the interactive nature of violent video games, where the minor or the young adult is the aggressor, is the individual acting out this obscene level of violence, if you will, is especially harmful to minors.
Well, do you actually have studies that show that video games are more harmful to minors than movies are?
Well, in the record, Your Honor, I believe it's the Gentile and Gentile study regarding violent video games as exemplary teachers. The authors there note that video games are not only exemplary teachers of pro-social activities, but also exemplary teachers of aggression, which was the fundamental concern of the California legislature in enacting this statute. So while the science is continually developing, indeed, it appears that studies are being released every month regarding
Suppose a new study suggested that movies were just as violent, then presumably California could regulate movies just as it could regulate video games.
Well, Your Honor, there is scientific literature out there regarding the impact of violent media on children. In fact, for decades, the President, Congress, the FTC Parenting groups have been uniquely concerned with the level of violent media available to minors that they have ready access to.
I don't know, is that answering Justice Kagan's question? One of the studies, the Anderson study, says that the effect of violence is the same for a Bugs Bunny episode as it is for violent video. So can the legislature now, because it has that study, say we can outlaw Bugs Bunny?
Okay. So I'm not sure if I'll be able to get, right now, the audio of both arguments are embedded in my PowerPoint. I'm not sure if I'll be able to upload them to the blog site or if the files are too big. If the files are too big, I will just replace the actual embedded player with a link. Please go there. This is a good use of your time as prospective counsel. The Blizzard argument is a little drier. It's about 45 minutes. The Schwarzenegger argument is fireworks all the way through and just as tough on those arguing the First Amendment. So, I'm playing you one side, and certainly, in fairness, the lawyer for the state of California got the rougher ride, but there were some awfully good questions on the other side of the coin as well. So, don't be misled. We just don't have enough time. But the deeper question for today's purpose to ask yourself about Schwarzenegger is, okay, what are we protecting? Why? Is it simply the ability to create? Is it something more? So, I'm trying to quickly give you some answers, or things that pass as answers. The key to both BnetD, Davidson, and Schwarzenegger Brown, the first common denominator is creativity. If you're on a creative path, something different happens. Something different in law happens. That's why in Davidson, counsel in effect said, this is anything but a creative exercise. Modding, or this kind of modding. This is not such a case. There may be such a case, but this ain't it. So that's the power of the creative. So just remember, we had two different models of the creative. There is the creative Hollywood model, the mythological model, the God model. I have created this. It belongs to me, versus what seems to be better supported in the academic literature, which is that creativity is a team sport involving the world, and we get our ideas from everywhere, and it is a natural psychological process where we remix and parse through and recreate very often, if not most often, on a subconscious level. So where that takes us is perhaps a strange place. And this is the core debate around mods and copyright law and what is the role of creativity. If games Again, there's nothing new here. We've discussed this all, but just in all different parts of the course. If games require a player and someone who created the world, somehow working together, admittedly in different time frames. If games are inherently interactive, and if the player is a creator, then is that part, and this is for you to decide, is that part of creativity potentially more important than the art part that attracts intellectual property protection? That's a big question. In Schwarzenegger, it's not about copyright. It's about state intervention. It's about denial of works. Is the child's creativity spurred on by Grimm's fairy tales and Bugs Bunny more important or less important than the interests of the state in safeguarding society and making sure that the child is not too twisted by those inputs? An equally difficult question. And it's how you prioritize creativity. But creativity is at the core of both. And it's more obvious in the BnetD case because counsel just out and said it. And it's a little harder to find in Schwarzenegger because they focus a lot more on the creativity and rights of the producers of the game. But really, if you listen carefully, I think you might find that the justices are thinking, and in fact, at one point, it comes up in a slightly different way. They're thinking, well, what would happen if I didn't read Grimm's fairy tales as a kid? What happens if I didn't have access to Bugs Bunny? That's really what's being asked, in my view. And where it comes up, and you'll have to find it for yourself. We'll just make it an Easter egg in the Schwarzenegger case, but it's a wonderful Easter egg, where one of the justices hones in on, I think it was Street Fighter. So many of you who are gamers know Street Fighter is an excessively violent video game, arguably, where heads get chopped off and blood spurts out. And it's, sorry? Mortal Kombat. Thank you. You see, I didn't play these games. Mortal Kombat, not Street Fighter. And I guess the judges had been understandably briefed by their clerks, but several of them observed in asking questions about Mortal Kombat that all of the clerks at the US Supreme Court had played Mortal Kombat in their youth, or so it seemed to them. And they didn't seem worse for wear. So that lens of creativity affecting other people's creativity is at the core, perhaps, and if it is, then what do you do with IP law? It certainly weakens it. Anyways, not a better example than BnetD. Okay, another common denominator. This is equally difficult and challenging. Earlier in the course, I mentioned the Mrs. Smith principle, which is something I discovered when I was a newsroom lawyer. And that was the phone calls that happened after a controversial news item was put on the air, usually something political, and you would get calls seemingly equally dispersed between right and left, all saying the same thing. I recognize the nonsense that you just put across the airwaves. I recognize how horribly wrong it is. How could you put something so horribly, so obviously, so decrepitly wrong out there? So obvious to me, but I'm worried about Mrs. Smith down the street. She's so stupid, she's so inept, that although I see clearly how you are deliberately misleading me and the rest of the public, she won't. And it suggested that that was part of the core instinct of censorship. It's a sense of superiority. I'm going to suggest for the first time that there's here at least, that there's a version of that that applies to creativity. And that is that we have a very easy time, think about yourself, accepting that we are creative. But we have, for whatever reason, a more difficult time seeing other people's creativity. And maybe that explains the phenomenon where certain musicians, certain entertainers seem to very liberally borrow material and then are very quick to assert copyright over it and say it's mine. So there's a certain aspect of this which is just perhaps based in our ego. Love this picture. This is actually what it looks like apparently when a cold air front moves in and carries the clouds with it. Third common denominator between Schwarzenegger, which is a freedom of expression case, and BnetD Davidson, which is in essence an intellectual property end user license agreement case, is the chilling effect. Very well described by the courts in many, many different places when it comes to newsrooms and when it comes to libel chill. And even more recently around issues like contempt of court, publication bans. You can find a whole bunch of cases that talk about the chilling effect on media and the chilling effect on democracy. By not having information flow freely. Really don't hear a lot about copyright chill. We really don't hear a lot about IP chill. However, it's very real. If you have clients in this area, they spend an enormous amount of time really not sure what they can use and what they can't use. And it has fueled an open source movement, and that is good, and that is an antidote. And you're seeing increasing numbers of large corporations preferring to go open source on their software than not. Not because it's free, but because they can control outcomes. But the reality is the creators are affected. And even in a very small way, I've become way more sophisticated over the time of this course in going to Wiki Commons and figuring out what pictures I can use and what pictures I can't. And there are a number of slide presentations that you saw in this classroom that are not up on the blog because photos were used that, not that necessarily breached copyright, but no one knew if they did or they didn't. So then you have to go to the trouble of changing them or whitewashing them, and that takes time and all of that. So there is a creative chill to this. It is not talked about much, but it's real. So just in this chilling mode, a number of academic articles. I'll fix this before it goes up on the blog. But the main one, if you have time to read, is the Grimmelman-Bambauer dialogues. The main piece is Orwell's Armchair by Derek Bambauer, and it is an argument in favor of direct internet censorship. Not because direct internet censorship is good, but because it will be better and clearer and more legally parsable than indirect, which is where we are now. And Christina Mulligan's piece, in a sense, is an accompanying piece, although not intentionally, which argues that internet intermediaries should have virtually complete immunity, because if they don't, government will create a chilling effect on creators, on political views, et cetera, et cetera. These are all very responsible academic pieces. Mark Lemley applies the principle to where IP law is going, the chill. And then Joseph Miller, I probably should have reversed the order here, talks about overbroad IP laws for some of the same reasons, and then a case for the public domain by Clark Assay is a plea that the public domain and redefining it as broadly as possible may be a solution to some of these problems. So I'll fix the order there. So now in the next 15 minutes, I'm going to take all of this and when I say all of this, I mean everything in the course, plus today, and try and make the argument about mods. And to do that, because I want a small advantage, I will remind you of Einstein's quote, "The world as we have created it is a process of our thinking. It cannot be changed without changing our thinking." So if we're really going to find a way of solving the mod problem, which is the machinima problem, which is the fan fiction problem. It will require some change of thinking. Going to be very hard to get there without. And you know that the subject is important to me because I've ranted on it throughout the course, but you may not know why. As mentioned, my formative gaming experiences were not on Doom, were not on first-person shooters, but were on racing games, and in particular, a game called Grand Prix Legends, which was the first game with computer game with really good physics, in the sense that the breakthrough in Grand Prix Legends was that the physics model involved all four wheels of the car instead of the effect that you see in many games where the car seems to swivel on a center axis, on its center axis. And no car drives on its center axis. Cars drive on four wheels. And Grand Prix Legends was an amazing piece of gaming design, but it didn't really work out of the box very well. In fact, if you, and I welcome you, go to PC Gamer, Google PC Gamer Grand Prix Legends, and somebody tell me what the review score was. I think it was 3.2 or 3.1 out of 5 or something like that. Came out in 1997. Problem was, it was built for hardware that didn't exist yet. And the only hardware that you could get in terms of video, it required a video card. And in 1997, not everybody had video cards. It required a wheel and pedals. It was a very hard to access game, as brilliantly engineered as it was. And on a normal computer, if you could get it running, it would run at 6 frames a second, which for a racing game, let's just say, isn't very good. Stutter City. What happened was there was one patch which fixed some issues and made the game somewhat serviceable. But a community jumped in, created multiplayer where there wasn't multiplayer, and fantastic multiplayer, populated forums, created skins. You can see the difference between the original game and the skins that were produced. And the game had a life of 10 years. And it was very, very popular until 2007. And then eventually age caught up with it. You can still find it and people still play it. I think I removed it from my hard drive about a year ago. And that was hard to do. But in this, and all of this was driven by the community. And I think the people who produced the games were somewhere in the background. I think they were either helping. Well, I'm sure they were helping. They certainly weren't hurting. They didn't have the money to fix the game, and the community jumped in and did. And there were never any real issues. One day, sitting on the forums, and you have to realize that a lot of work goes into, and no one's being paid for it, turning that into that. And it would take, 6 months. You'd wait for each car to be released, and you'd feel like you were collecting them. And one day, a woman wandered onto the forums, and announced that her father, who was very ill, had been a Formula One driver in one race of the 1967 season in New Zealand or Australia. And would it be possible, because she had heard about this modding community, I always get choked up, would it be possible to create or recreate her father's car in the game? And it was seconds before the leaders of the community took the conversation offline, and it clearly happened. So there is something magical about modding done properly. And my understanding of modding really comes from that experience. So where does that take us? Well, we just talked about it, so I'm not going to go through it again. You've got two memes of the creative, the everything is a remix versus the Hollywood model. But then we have this. Education is modding. Everything you do, not only does it use other people's work, it must use other people's work, and it must attribute that work, and it must build on that work. And if you are a serious student, you will transform that work. You will transform those cases. You will transform those precedents into new precedents. And you will make them better. And you will build the law. And that's not restricted to law. We just happen to be in a law school. That principle applies to education generally. But while we're on law, I've made my point. What you must not do is plagiarize in education. That'll get you kicked out. That's on the course syllabus at the request of the administration for a reason. So build, but don't do a straight out copy. Build on. It's all modding. First problem is we don't accept other people's creativity. I went on about that. I'm not going to do that at length. Second problem we have to grapple with is at one time the idea-expression dichotomy was in balance, as we've discussed earlier in this course. And you could have an idea and it could gestate, and then it would become fixated. But today, we're out of balance. It takes a split second for an idea to become an expression. Any idea that's expressed in this class, well, it's on tape, so it's been fixated there. It may be fixated on in your notes. Somebody may be live tweeting this. I doubt it. It's not worth it. But you get the idea. And then, ooh, that's interesting. Oh, wow. All right. I don't know how that happened, but then we had a discussion about the trajectory of creative freedoms. And we talked about where the Statute of Anne came from and how originally the Statute of Anne, which was the first Copyright Act, was not necessarily about copyright. That in fact, its genesis was in freedom to express and freedom to speak, and parenthetically, freedom to create. That originally the right to censor was in the king. Put up the whole slide. And it moved to Parliament, to a regulator, to industry regulation, self-regulation. And this was all the power of censorship. This was pre-copyright. And then it moved to the one place it could go, and that is the author. And that was in 1710, because there was nowhere else for it to go, really. There wasn't modding in 1710. There wasn't remixing, per se, in 1710. But today, there is a place it can go, thanks to digital technologies, and that's to users. And then finally, we get to the argument that was made at length over 2 talks, that the cases neither allow nor prohibit modding. That none of them do. And I'll refer you once again to what you heard from Blizzard's lawyer in the Court of Appeal. No, no, no. This isn't about creativity. Well, what about modding that is about creativity? So I won't regurgitate what's been said in other lectures as to how to parse these cases, if you choose. But we'll put it to you again that all the cases, and they are only a limited number, can be understood and rationalized, in fact, as pro-user, pro-gamer rights cases, including Davidson. Because Davidson and the botnet and the Blizzard botnet case all preserved the copyright rights of the users. And even in MDY, which was the botnet case, where the producer of the bots was punished, the users of the bots, the gamers, were protected by the courts. And in that sense, at the very least, it's hard to argue that the gamers, the users of the bots, are not modding the game, because they are modding the game. They are changing the game by using the bots. So let's for a moment suspend reality and pretend that you are convinced that modding should somehow be protected, and that you will dedicate your legal career to that worthy purpose. How are you going to do it? What are the tools at your disposal? First tool, remember, Games and Other Uncopyrightable Systems by Bruce Boyden. Not about video games, about how games are uncopyrightable because we play them and they're interactive. And it's the art that attracted copyright. It was Atari in Oman that attracted copyright. Very low threshold. This must be art. But without the art, you just have a game, and there's no copyright. So one argument, and all these arguments will run into each other and meet each other in a sense, is to recast video games just as games. Another way, and you'll remember the reference to the Dutfield-Sotherson paper, which looks at what the UK should do with its intellectual property law. And the suggestion there is, you know what? Maybe we need to raise the thresholds for IP protection. Maybe they shouldn't be as low as Otari and Oman. Because we have to ensure that copyright law doesn't, quote, ensnare essential information and elements that form a part of the knowledge base, which in turn impedes the progress of follow-on innovators. So make copyright tougher to get, not easier.
But if it's functional, it wouldn't have a copyright protection on its function.
Right.
So that shouldn't really stop the progress that they're talking about, should it?
Well, there's a paper that somewhere in the materials, or an article somewhere in the materials, where that talks about how we've gone from applying intellectual property to the solution and have made it so that we're applying intellectual property protections to the definition of the problem. So anytime something appears new, I had a visit to my office yesterday on exactly this. Somebody came in and said, I can solve this problem. I want to protect it. Well, how are you going to solve this problem? Well, I don't know, but I've identified the problem. If I solve it, will I be able to protect it? Well, come back when you've actually solved it, and maybe we can look at how it may be protectable. So I think the threshold has gone very low, and so that's one aspect in terms of the psychographics of how people are approaching the problem. And the other aspect is the straight-out Otari and Oman problem. I mean, I cast that at the beginning of this course as video games fighting for their rights. But the net result of that very low threshold is that no one can mod Breakout, in theory. Think about that. So, and yes, you could say this is a genre, and therefore you can do something Breakout-like. And we had that whole discussion when Jennifer was here about Sens Affair and how to parse this out. But none of that has prevented a lot of lawsuits and a lot of money and blood being spilled over where the line is, and it remains extremely unclear where the line is. So, third way, we've talked about the Supreme Court of Canada, and I'm going to spend a bunch more time on the pentology next week. Next week is going to be about moral rights and the pentology and how it solves a bunch of problems, including potentially the EULA problem, and maybe even some of the privacy issues. So that's, and then the final is the notion of context shifting, and that's revisiting Sony and Universal and saying time shifting for the digital age. If we come up with time shifting as not being a breach of copyright, when you're actually copying something onto a tape, then surely we can find a way to create some latitude for digital information for the base part of digital information so that it can be created with in some real way, and we don't impede that further creativity, as long as it's not plagiarism. So, and then the most direct way, and the most far-fetched, is a straight-out right to mod, right to create. That would essentially come about in by one of the methods I outlined. But whatever we do, hopefully we can address the reality that in games, creators are users and users are creators. And we can come up with a legal way of accepting that reality and supporting it so that everyone, including my very creative 11-year-old daughter, can benefit, both by being a user and by being a creator. So that's part one of conciliation.